This is a restricted lot. ID. Now.
Good morning. My placard's on the dash and my name's on the post behind you.
I don't care whose name is on the sign. Against the car.
Officer, my credentials are in my pocket. Let me show you.
You don't get to make demands here.
I'm the chief judge of this county, Tafemi, and that name on the post you never read is mine.
At 8:13 a.m. on a Thursday, a police officer 10 weeks out of the academy put handcuffs on the chief judge of the county he was sworn to serve in her own reserved parking space in front of 2 cameras he didn't know were running. He thought she didn't belong there. Within 72 hours, his badge was gone, and the county was drafting a settlement for $7 million. Before we go further, where are you watching from? Drop your city in the comments. I read them. And if this is your first time here, hit subscribe. We cover one thing on this channel: what happens when power meets accountability. One note before the story: everything you're about to hear is a composite built from documented patterns across real civil rights detention and failure to supervise cases. The names, the county, and the figures are illustrative. No, the pattern they're built from is not. Dylan Mercer was 24 years old and 10 weeks out of the academy, assigned to exterior security at the Hartwell County Courthouse, a limestone building from the 1960s, renovated in 2014. His training file already told a story. Academy evaluators had flagged a pattern. They'd written that he escalated routine contact and asserted authority beyond his competence under stress. 2 instructors recommended additional field supervision. The recommendation was noted, then shelved. The department was short 14 officers that quarter. Mercer met the minimum standard. He got the badge. For 10 weeks on the lowest stakes post in the building, nothing happened. Then, on a Thursday, the woman in the reserved space happened. Her name was Adrienne Caldwell. She was 58 years old, 26 years on the bench, and 4 months into her term as chief judge of the Hartwell County Circuit Court. That morning, she wore a charcoal suit, carried her own coffee, and had no escort. To a 10-week rookie, she looked like nobody in particular. It was October 9th, a Thursday, 8:11 a.m. The secure lot held 12 reserved spaces, each with a nameplate bolted to a steel post. Caldwell's read, Chief Judge, Reserve. She had parked there every working day for 4 months. Mercer had rotated onto the East Post that morning. He had never seen her. He had not read the plates. He saw an unfamiliar car in a restricted lot and a woman he didn't recognize stepping out of it. The body cam was already recording. Mercer crossed the lot fast. Caldwell turned, coffee in one hand, keys in the other. The footage shows his eyes never leaving her face, never dropping to the plate 4 feet away. When she reached slowly for her judicial credentials, narrating every motion the way someone does when they've watched these encounters go wrong, he cut her off and ordered her against the car. The credentials never made it out of her pocket. For 10 weeks, Dylan Mercer's job had been to keep this lot clean. He was about to turn a parking question into a federal lawsuit, and he had no idea the woman in front of him signed the warrants his department lived on. From here, the timeline tightens to under 2 minutes. 8:12 a.m. Caldwell asked twice to retrieve the ID he had just demanded. The body cam caught his answer clearly. 5 words that a deposition would replay 14 months later, that she didn't get to make demands here. By 8:13, 2 things were happening that Mercer couldn't see. A maintenance worker 15 feet away had started filming, and Mercer's field training reference was walking up behind him. Close enough to read the plate, Mercer never checked. That officer put one word over the radio: stand down. Quick gut check, because this is the hinge of the whole case. Should a direct stand down from a senior officer in the field be the end of it? Yes or no? Drop it in the comments before you hear what he did. He didn't stand down. At 8:13 a.m., Dylan Mercer placed the chief judge of Hartwell County in handcuffs against the hood of her own car in her own reserved space in front of 2 witnesses and 2 cameras. The maintenance worker's video would clear 4 million views before the week was out. The cuffs were off within 90 seconds. The senior officer reached the plate, read it, and intervened. Caldwell never raised her voice. Witness statements later filed with the court record only one instruction from her as the cuffs came off: that everyone present preserve their footage. Then she walked inside, rode to the 4th floor, and called the county's chief administrative judge before her coffee went cold. By 9 a.m., the general counsel knew. By 10:30, the footage was locked. By noon, Dylan Mercer, a sworn officer for 10 weeks and 3 days, was on administrative leave. Internal affairs took 5 weeks. It wasn't complicated. There was body cam footage, bystander video, 2 corroborating witness statements, and a radio log showing a stand down at 8:13 a.m. According to the Internal Affairs report, investigators sustained 3 violations: unlawful detention, failure to obey a lawful order from a superior, and conduct unbecoming. Then, the report surfaced the thing that turned one rookie's mistake into a county problem. This was the 3rd complaint against Mercer in 10 weeks. The first 2, both for escalation during routine contacts, were still sitting unreviewed in a supervisor's queue on the morning he reached for those cuffs. The academy warnings, the 2 open complaints, the shelved supervision order, none of it acted on. Mercer was terminated the day the report closed. By then, the county's exposure had stopped being about him. If you've made it this far, you already see where the real failure. Subscribe so the next case finds you. We put one of these out every week. And Caldwell didn't sue Dylan Mercer for having a bad morning. She sued the county for the system that produced. The complaint, filed about 3 months after the incident, ran 3 counts. Count 1, unlawful seizure under the 4th Amendment through 42 U.S.C. Section 1983, the detention and cuffing without cause. Count 2, First Amendment retaliation, escalation that intensified after she identified herself. Count 3, the expensive one, a Monell claim against the county itself, not for what one officer did, but for the pattern. The ignored academy flags, the unreviewed complaints, the shelved supervision order that made the harm foreseeable. Here's why that count carried the number. An individual officer can raise qualified immunity. A documented failure to supervise claim is far harder for a county to wave away when the paper trail is sitting in its own files. The county's lawyers watched the same footage everyone else had. They settled. The settlement closed about 16 months after that Thursday. $7 million, with roughly $2 million earmarked for reform. That figure is an illustrative composite. In real litigation, a clean failure to supervise record drives the number far more than a brief detention, but the money was never the story. The agreement specified non-monetary terms, and those outlived the check. The county adopted a mandatory same-week review window for officer complaints. It restructured how academy flags follow an officer into the field. A supervisor and a records administrator were reassigned. The 2 officers stacked ahead of Mercer in that complaint queue were retrained. Dylan Mercer never wore a badge, and the reserved space on the east side of the courthouse still has a steel post and a nameplate that says Chief Judge. This is what these stories are actually about. Not one rookie having a bad morning, a system that saw the warnings in his file, in 2 open complaints, in a recommendation it buried, and chose every single time to look away. The handcuffs were Mercer. The failure was the county. If you believe stories like this matter, if you believe accountability shouldn't depend on whether the person in the cuffs happens to outrank you, hit subscribe. We're documenting the patterns the system would rather file under unfounded, one case at a time. New one next week. We'll see you there.